All rise. Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. This is the last case we have this morning. Thanks to counsel for appearing and presenting us arguments. We'll go on and call the docket. And since the attorneys have been here many times, we'll forego talking about admonitions and such. So we have 5 cases: 07-24-00110 CR down through 00114 CR. And it is Larry, Glen, Rolen versus the state of Texas. Mr. Bennett for the appellant. You are ready?
Yes, sir.
Thank you. And Mr. Rolen for the state. You are ready?
Yes, sir. State, sir.
Very good. Mr. Bennett, it's all yours.
Thank you, Your Honor. May it please the court, Mr. Rolen. How long must we indulge the argument that despite the obvious pointlessness of making further objections in the trial court below, the argument that the appellant didn't say Simon Says in the trial court, so now he's out of luck. You've got to affirm it.
Until the CCA says we don't have to indulge in that argument?
Under Thomas, it
We're
did.
the ones that said that we have to determine preservation, and you've got to abide by preservation.
Of course, but if it was obviously pointless to argue further below, then as the Thomas court and as this court said in In re Brown in 2013, a common sense application, not a rigid one, is proper.
Does our common sense supersede the CCA's edict?
Yes. Not that edict. Common sense supersedes the rule that unless you object to for the jurors being seated and ask for more peremptories and name the jurors that are objectionable, that common sense should take precedence over that.
And who created that rule?
I believe the Court of Criminal Appeals.
Okay, so our common sense can supersede the CCA's rule.
But the CCA has said,
even though we would many times like that to occur.
Yeah, but the CCA has said that it can supersede it in particular situations. We're not asking the court to overrule that case law, just to rule that in this case, the particular circumstances indicate that shouldn't apply. Counsel here below didn't name all the jurors like mentioned, but he gave all the numbers, and he said several times that these need to be excused for cause because they answer the question. The question was, is there anything that you can think you can be told by the judge that would convince you in your mind you can eliminate the bias you expressed? They said no. The state brief says that answers of no to that are not the same as a juror having a conclusion that would influence the verdict. This is bewildering. Bias so deeply embedded that even the trial court's jury instructions won't cure it is patently a conclusion that will influence the verdict. If a restaurant server tells me, oh, you can order your meal the way you like it, but the chef won't do it, then that restaurant, like these jurors, should have been crossed off, will be crossed off my list, and those jurors should have been crossed off the list. Excused. You can't follow the court's instructions? What kind of a juror is that? I wouldn't put up with it. The state brief admits trial counsel persisted in his expressed desire to challenge for cause those who answered no to that question. The state's appellate attorney, and this is not a shot at Mr. Owen, but it's just obvious that the state attorneys, at trial and on appeal, just from reading the record, understood the substance of this objection. So did the trial court, and there it was. The substance of the objection must have been crystal clear to everybody around. Here, multiple objections, in fact, were made long before peremptory strikes were made and overruled or denied. So what's the point of making further objections? I don't see any. By the way, I apologize for the miscount in my opening brief. One panelist said no to the ultimate question twice. So there were only 12 left on the panel after the purported rehabilitation, not 13. I hope I adequately corrected this in my reply brief. But the harm...
And the defense counsel asked for more peremptory challenges?
No, but it was obvious that he wasn't going to get...
Could the court consider his silence as saying, well, I guess he's okay with those guys?
not according to Thomas, because in Thomas, even though the defendant made an objection and later said something about that might say we withdraw that objection, the overall thing said that the later objection was not intended to withdraw the objection. Here, neither Mr. Rolen nor his attorney made anything that did anything that might indicate any affirmative action that might have been that, oh yes, we're withdrawing that.
I think in your brief, you argued that it would have been futile to request a dozen additional preemptory strikes. Why
Actually,
would it be why would you need a dozen more instead of just 2 more?
because there were 12 jurors, two were subsequently removed. 10 remained on the panel who had said, no, I can't or I won't obey the judge's instructions. Therefore, counsel, unless there was something else that was even more damaging that a prospective juror said, he'd have had to use all his peremptory strikes to remove these jurors who should have been gone long before. Yeah, there were 10 that remained. As I noted in my reply brief, the Texas Supreme Court has very recently ruled that imperatives favor the determination of cases on their merits rather on harmless procedural defaults. That's pretty much what Thomas said.
But he could have used some of his preemptory strikes on those 10. And then the remainder, he could have asked for more.
He could have.
Right. So instead of a dozen more, maybe you just needed 2 more.
But then harm is clear because you have used 8 of your peremptory strikes.
But you would agree with me it's more likely to get a request for 2 than a dozen.
Of course, but he was still prejudiced by that. Let's see. Newbury versus State, 135 Southwest 3rd, 22, says that even the loss of one peremptory via failure to properly excuse a panelist is inherently harmful so long as the defense uses all its strikes, which defense counsel here did. In Newbury, the defense counsel didn't, so it was affirmed. But where a defendant loses not one, but possibly all 10 of his peremptory strikes, I can't think of an adjective strong enough. There's no question this was harmful. And it was because the trial court did not follow the 3516 and excused those jurors who said, I can't or won't follow your instructions, Judge. This is, to me, unconscionable. The state brief also urges you to defer to the trial court's decision because the trial court was in a better position to observe each panelist's demeanor and judge if each was vacillating. This is not that kind of situation. This is not a juror's vacillation or the juror said one thing but meant another. This is the trial court's error. The trial court didn't follow the law, and there went the peremptories. And that this is not a matter of did the juror seem like he was saying yes when he was saying no. They said no. I wasn't there, but I can't. The record doesn't indicate that any of them said, well, no, instead of no. The state brief says the panelists weren't asked, nor did they indicate whether they had formed a conclusion that would influence their verdict. This is nitpicking, as Thomas barred. The panelists plainly said that a conclusion existed in their minds that would influence them in finding a verdict. This past November, the court ruled in the Firmus Centro case that when a trial court fails to analyze or apply the law correctly, it has clearly abused its discretion. For me, at least, the state's brief, not Mr. Owen himself, but the brief, has a whiff of desperation. And this gets stronger when one reads the state's brief plea of unpreserved error to Mr. Rolen's second claim, after also reading many comments made on a major Emerald News website about a judge that wouldn't recuse himself. Yes, there was a valid reason that Judge Woodburn dismissed the civil suit, but laypersons are unlikely to realize the import of a settlement in a civil case and therefore a dismissal. Also, the article did not say that they made a settlement with Mr. Rolen, only that the insurance company and the bar that purportedly overserved him had made a settlement. So they reached their own decision, and they reached their own conclusion, and the conclusion was, in some people's minds, that the judge should be prosecuted, he should at least resign. And while this is absurd, that's what jurors were likely feeling. The people who commented on that site, they may not have been residents of Potter County, but who can say they weren't? And who can say that they weren't jurors number 32 and 34 who said, no, I cannot or will not consider the judge's instructions, and were not removed. And peremptory strikes were not enough to remove them. As 18BB requires, it's unlikely to realize that the public to realize that a settlement approved by a trial court means dismissal of the civil suit. It seems the people who answered that, the news article, thought it was that the actual case against Mr. Rolen had been dismissed.
Apparently this relates to the ground of partiality, appearance of partiality.
Yes, indeed, Your Honor.
Was that raised at trial?
It was tangentially, but it
Also,
was certainly there for the judge to consider it. It was in the motion, and trial counsel said, this is what happened.
well, you said tangentially. What were the grounds for recusal asserted in the motion, the exact grounds?
That the judge had was privy to
Personal.
yes,
Did it say partiality in any way?
no, and it was misnamed, and I realize that's a
Okay, there was a hearing, if I'm not mistaken, correct?
yes, a recusal hearing in front of Judge Estevez. Yes,
Was partiality broached there?
in the hearing, yes. Where are we? The defense counsel said Judge Woodburn caught a lot of flack from the readers of the news source that published the facts around the settlement. And the trial court, the recusal court, ruled in writing that the defendant failed to show any grounds for recusal. That's an explicit rejection of it. Sorry, Judge.
Anybody mention partiality expressly? Mentioned partiality, he should be recused at the hearing.
At the
It's
hearing,
not in the motion, at the hearing. Did anybody expressly mention partiality or bias or anything along that line, as opposed to there are certain people who commented and they didn't like what he did?
not in so many words. No, you're right. However, saying Judge Woodburn caught a lot of flack from the readers that published the facts. That news article said civil suit dismissed against the families of the victims of this crash. That was the title of it, bold letters at the very top. And then later you read in the fine print that the settlement was reached with the insurance company and the bar, but it doesn't say the settlement was reached with Mr. Rolen. And it seems, even if a layman knows the meaning of civil suit, and many don't, it looks like the criminal action against Mr. Rolen was dismissed.
So the people who were making comments about this article didn't read all the article?
I'm sorry, Your Honor?
So the people who were making comments about this article, which you're relying on as basis to remove, didn't read all the article because they'd have read that really the judge had nothing to do with the settlement?
I don't know what they read, but I'm sure they read the headline. Whether they read the rest of the article.
The headline is maybe not accurate reflection of what occurred.
It is accurate, but it seems to say that something has been dismissed against Mr. Rolen. And people in their rush to judgment will take it that the criminal action has been dismissed against Mr. Rolen. And yes, they felt this emotion that the victims' families are getting nothing, and nothing would suffice for the loss of their loved ones. That's what a perfectly valid understanding, but not from this case, not from the civil suit, because the civil suit was settled and it was dismissed.
Now, the test for appearance, recusal for appearance of partiality, doesn't the standard refer to ordinary people or reasonable people or something like that? What do you recall that?
Yes, reasonable people who, knowing all the facts in the public domain.
All the facts in the public domain. And you're saying there's evidence imparted of appearance of impartiality due to comments regarding the article.
Yes,
Okay. But if you read the article, those comments would be baseless because it wasn't a dismissal of Mr. Rolen. So would the people on whom you're relying as evidence of reasonable people to show appearance of impartiality, reasonable people, if they didn't read all the article?
hypothetically reasonable people, Your Honor, but these people who answered are at least literate and they understand something. Whether the general public, the hypothetically reasonable people understood that is
You're looking at, you said you look at all the evidence in the public domain. The
true.
entire article would be something we'd look at, which would indicate they didn't know what they're talking about.
Unfortunately, I'm not convinced, and this is just me, that the average person knows the difference between a civil suit and a criminal action and understands what dismissal by settlement means.
Why only this subset of people? So if we're looking at a reasonable person that knows all the facts in the public domain, obviously it's still in the public record that the criminal charges are still pending. That's what we're going to trial for. Why don't we include all the people that would also know about the criminal charges still pending?
Because laypersons are unlikely to understand that. And it asks the standard in 18BB.
But would a reasonable person understand it?
A reasonable layperson?
Yes. They know all the facts in the public domain. The criminal charge is still pending. The civil cases have been dismissed. Why are we looking at just the people who are commenting on that article?
Because they at least follow to some degree the news that's presented to them.
And with that subset of people, the people that commented on the article, just that subset, would they fall into the category of reasonable people who know everything in the public domain?
I would think so, yes.
But they don't know about the criminal charges still pending?
They don't.
And
But
if they read the article, they would have.
no, they wouldn't. The article dealt solely with the civil suit. But people jump to conclusions.
They would have reasonably inferred that the criminal charges weren't dismissed if the settlement related only to the civil suit. Of course, I'm playing devil's advocate.
Of course.
But
Well, the people would, I imagine, think that there might be a criminal case. Whether that has been settled also, it wasn't mentioned. And the title of the article was blazingly, this judge has dismissed this suit against this man charged with killing people because he was drunk. To me, that's not even a reasonable person is going to look at that and have strong emotions. Valid emotions, maybe, certainly, but not correct.
I wanted to make sure I didn't miss a point you were trying to make. You mentioned earlier in a response that Judge Estevez's ruling was there are no grounds for recusal. And I wanted to make sure I didn't, is that something that is of import that she phrased it that way?
Yes, because he got a ruling on the tangentially raised objection. The tangentially raised
appearance of impartiality.
I see what you're saying.
Or appearance of partiality, excuse me. She implicitly ruled on that?
She said no objections are valid.
Yeah. So
Yes.
you're saying she implicitly considered appearance of impartiality, even though it was not in your written motion?
Not in those words, Your Honor, but there would have been a little point of including at the printout of those comments about the judge that he's a crook and he needs to resign and he and Mr. Rolen may be pals. But it doesn't, the ruling does cover it because she said all of the things. And one expects.
So that ruling also covered second degree of consanguinity and financial interests and all that other stuff? Because she said there's no grounds?
She said there's no grounds. And one imagines, one hopes she read the motion and looked at the comments.
She said under no grounds for recusal under Rule 18B, paragraph B.
I'm not prepared to answer that. I'm sorry, Your Honor.
Well, that's what the order says. And I think the other,
Paragraph B,
yes,
18BB, well, both reasons, the partiality and the knowing being privy to too much information are covered under 18BB. What the first one is 18BB1 and the I believe, and the second one is 18B3. So yes, it does, in my opinion, it does cover.
What's 18BB2?
Excuse me?
What's 18BB2? Did she cover that one too? And is there a 4? Did she cover that one too? And a 5? Did she cover that one too?
I think there are about 9.
Okay, so
but
she covered
those-
all 9,
Those were,
even though they weren't raised.
this one was raised implicitly, otherwise there would have been no point to including all those comments in the brief as, excuse me, in the recusal motion as trial counsel did. If the court has any further questions, I see my time is almost up, but
Well, the state has conceded to the third issue,
yes,
right?
yes.
So-
I'm sorry, Your Honor, I don't know.
Just wanted to verify that.
Just wanna make
yes.
Sure, yeah.
Yes, but that's a fees issue.
Okay.
And Mr. Rolen has sentenced to a total of 45 years, so the fees issue probably doesn't have much meaning to someone like that. Anything else, Your Honor? Thank you, Your Honor.
You do have 5-minute rebuttal.
I beg your pardon.
You have 5-minute rebuttal.
Oh, thank you.
May it please the court, Mr. Bennett. Initially, the state will affirm that we have conceded that on the matter of cost, only one case should be allotted for the court costs under whatever that article is, 102 something in the Code of Criminal Procedure. Two contested issues are presented for this court's determination. The first is whether the trial court erred in not immediately discharging 11 veneer panelists who initially said they could not set aside their bias against appellant formed from media coverage about the underlying event, leading to these intoxication manslaughter prosecutions, even when instructed to do so. The second is whether the trial judge, Judge Woodburn, should have been recused because his impartiality might reasonably have been questioned. The state's threshold position regarding both of these issues is that appellant forfeited review by failing to lay a proper procedural predicate in the trial court. Beyond that, in both instances, appellant's arguments are unsustainable on their merits. Now, the scenario in which the jury selection proceeding was essentially this. In referring to page 105 of the volume 2 of the reported record, defense counsel asked if anyone had heard about the case in the news. 25 panelists affirmed that they had. On pages 107 and 108, counsel asked those 25 from the media reports, they were starting out a little biased against appellant. 15 panelists indicated that they were. Counsel then on pages 109 and 110 asked those 15 panelists if more likely than not, what they heard from the media would enter into their deliberation process. 14 panelists answered affirmatively. Counsel's follow-up question on pages 111 to 113 of reported record volume 2 is there anything that you think you can be told by the judge that convinces you in your mind that you can eliminate this bias that you've expressed? 11 panelists responded no, and 3 indicated yes. So the panelists initially expressing a lack of receptiveness to any instruction to set aside bias for the subject of his initial causal challenge. But in the process,
With regard to the ones who answered no,
I'm sorry.
with regard to the ones who answered no,
Yes.
no. Who's on first? With regard to answered no, did the questioning have to stop at that point? And then the court had to determine whether to remove them, or could you have rehabilitated? And I'm trying to remember, it's been a while since I've read the briefs, but I thought opposing counsel was citing a statute or a rule that said once they indicate a bias, that's it. They've got no opportunity to rehabilitate, basically.
Well, yes, but the statute is 35.16A10 of the Code of Criminal Procedure. But that statute provides that once a panelist affirms that they form such a conclusion in their mind about the guilt or innocence of the defendant that it would influence their verdict. Well, that didn't happen here. They just all the counsel asked is, have you expressed do you have a bias that you not be able to get out of your mind from reading the media reports?
You gotta specifically address guilt or innocence in that bias.
Yes. Yeah. So, but yeah,
For the
you've
statute
got to
to
go
apply.
further than just bias. You got under the statute, you have to basically bring evidence that they had formed a conclusion of the guilt or innocence of the defendant, and would be unable but that would affect the verdict. That would affect their deliberation.
Can the trial court, or can we infer, or anybody infer that when they said, yes, we have a bias, no, we can't put it out of our mind, that it relates to guilt and innocence?
No, I don't think you can make that inference. In that connection, 35.16A9 says that one of the grounds of recusal is that the person has a bias against the defendant. And there'd be no problem with rehabilitation. So of those 11 panelists, one panelist 30, said he or she, whoever it was, saw the accident and was immediately excused by the judge. That's found on page 117. Two others, panelists 24 and 37, said they would not listen to the evidence, and they were excused without objection. So every other panelist affirmed that they could set aside any bias and base their decision entirely on the evidence presented. So they're effectively rehabilitated. So the appellant's complaint is that the 11 panelists initially responding they would be unable to set aside their bias, regardless of what the judge told them, should have been immediately discharged under 35.16A. But the appellant did not lay a proper predicate for this court's view of that complaint. I think significant in this is found on the sealed volume 2 of the clerk's record, which has the strike lists of the parties. And I think maybe Mr. Bennett might have been confused in looking at those, because this case initially ended in a mistrial back in September of 2013. And the jury strikes were from that case also. But further in the record, on pages 37 through 39, they have the strike list from Mr. Quackenbush, the defense lawyer in this case. And of those original 11 that expressed a bias, that initially that they could not follow instructions to disregard the initial response, of those, the defense struck only one panelist. So only one out of those 11 were actually struck. So obviously the appellant did not exhaust his peremptory challenges. Also, he didn't assert to the trial court that he was forced to accept an objectionable panelist, and he didn't ask for additional peremptory challenges. So rather than being nitpicking, as Mr. Bennett puts it, if this falls short of following the political, the procedural procedure,
Preservation.
that makes absolutely no sense. The following the correct procedure for advancing a challenge for cause. The Allen case that the state cited in its brief kind of sets out seriatim with the steps that have to be taken to preserve error for the denial of a causal challenge. But this is simply the threshold question of procedural default. Aside from that, he presents no credible basis for relief on the merits of his complaint. his reliance on 3516A10 is misplaced. That article provides that a ground for causal Jones is a showing that a conclusion has a conclusion as to the defendant's guilt or innocence as would affect the juror in finding a verdict. Again, counsel did not fail to ask those questions, and there's nothing that reasonably could be regarded as substantially along those lines. Merely asking whether a panelist harbored a bias from news coverage does not trigger an automatic disqualification without further inquiry. One other case I would cite in this regard that I did not cite in the state's brief, Harris versus State, 784 Southwest 2nd 5 at page 25.
You say
that
could you provide the volume and page number again?
It's 784 Southwest 2nd 5 25. That seems to be sort of the seminal case of this area. The proponent of a causal challenge under 810 must show that the prospective juror has established in his mind a conclusion as to the guilt or innocence of the defendant, as that will influence the verdict. The cases have held that both those questions must be shown some showing as to both of those, that he has a conclusion as to the guilt or innocence of the defendant, and that such would influence the verdict. Appellant's second issue, complaining of the failure to grant the motions to recuse the trial judge, suffers from the same substance. Again, the state submits that review of the complaint should be deemed procedurally defaulted. It's clear from looking at the motion to recuse that the appellant grounded his motion to recuse under Texas Rules of Civil Procedure 18B B3. In looking at the state's brief in preparing for this, I realized I kind of butchered the citation to that. It's 18B B3. But that requires recusal where the judge has personal knowledge of disputed evidentiary facts concerning the proceeding.
Was there only one ground raised in the written motion?
Yes, only one ground. And
Okay.
yeah,
It was specifically pled, right?
yes,
That you
yes,
just mentioned.
yes, yes,
It's B3,
yeah.
18B.
Now,
Why was it, was B1 partiality?
yeah, that was not raised in the motion.
I understand, but B1 pertains to partiality.
Yes, yes, it is.
Was
18B
it-
B1 is.
Opposing counsel argues that was implicitly addressed by the trial court and implicitly an issue at the hearing. When the court said no grounds under
Well,
B.
that's pretty broad.
Address that. I mean, why can or can't we
Well, initially, if the court would look
interpret
at,
that as an implicit attempt to address it?
well, first, initially, we point out that under Article 18A of the Rules of Civil Procedure, it says that the grounds have to be set out in the motion. And that obviously wasn't here, so I don't think we should be concerned with whether there's some inference or implicit. But I don't. It'd be a very strange reading of the record indeed that would say that that was implicitly raised and ruled upon.
Have you encountered a case that said that even though the rule says it has to be raised in the motion, if a ground is raised orally at the hearing, the case said, well, you can't consider that ground because it wasn't raised in the motion? Do you have any case actually saying that?
No, I have no case that says specifically that, but there are plenty of cases that say that if the ground that's argued on appeal is not what was raised in the trial court, then it's forfeited.
They're referring to the trial court. They don't say the motion. Correct. I know what cases you're talking about. Generally, the grounds have to comport between the trial, those raised in the trial court and on appeal, or else they're waived. The ones on appeal are waived.
Yeah.
Okay, but they relate to raising it in the trial court as opposed to this particular circumstance where it has to be raised in a motion.
Yes, I mean, I think, yeah, I think just,
But your argument would be it wasn't even raised in the trial court.
right, yeah. I mean.
Well,
it's all-
is
it's
that,
all-
is that your argument? I mean,
Well-
your argument is it wasn't in the written motion and the rule requires it to be in the written motion.
Yeah.
Are you also arguing that if we read the record in a different light, it was not raised orally? Or or do you agree it was raised
No.
orally at the motion? At the
Our,
hearing?
our position was not even raised orally. There's no, I mean, it's obvious in context that Judge Estevez was focusing on the, whether or not Judge Woodburn had personal knowledge of disputed evidentiary facts. It wasn't addressed to anything beyond that. And as I think it was, I believe it was Justice Quinn, Chief Justice Quinn mentioned, well, what about all the other ones? Did it cover that? Well, there's, I think, like 8 different grounds for recusal.
Well,
Yeah.
the order does say, it cites, the grounds for recusal under Rule 18BB.
Yeah.
And then specifically, the court finds that the Honorable Judge Doug Woodburn does not have personal knowledge of disputed evidentiary facts. Was that in the order? Was
Yes,
that
that's in the order, that's in the actual, the written
That's
order,
in the written-
the Judge Estevez signed that, yeah, that Judge Cooper did not have specific, or did have personal knowledge of disputed evidentiary facts in the criminal cases.
What else you got for us, counsel?
I'm sorry, Judge, I didn't hear.
What else you got? What else do you have for us? Did we cut you off and get you off track?
Oh, no, well.
Of questions? We have a tendency to do that.
Well, it's easy for me to get off track, but, well, yeah, one point I wanted to make is a kind of a curious remark on page 31 of the appellant's brief. As far as the, suppose the impartiality aspect, it would seem that the impartiality, whatever that would sort of inure to the appellant's benefit, because all this vitriol or whatever in the commentary from the few members of the public in reading this website report of the accident and the settlement, that seems, according to appellant, that would kind of signify a bias against Judge Woodburn. And it's kind of hard to see the logic and how that would harm appellant, even on its merit. But we don't, again, our primary position, we don't even get there because it was not preserved. There was not preserved. Well, as is often the case, probably something really will have occur to me at 3 o'clock in the morning, but unless the court has any further questions, I guess that's all I have to say.
If it occurs to you in the middle of the night, don't call us.
Okay. Thank you.
May it please the court. I presume as Texans, you all are Texas Rangers fans. Say you're about to watch on TV a game between the Texas Rangers and the New York Yankees.
Astros.
Beg pardon?
Astros. Sorry.
Or the Astros, one or other.
I like orange, okay?
Okay. You're watching on the pregame show, the umpire is being interviewed. Each umpire is asked, is there anything the commissioner of baseball can say that will remove your bias in favor of the New York Yankees? At least one says, no, that nothing can remove my bias in that favor. Does the state think anybody in Texas will believe that that won't affect the judgments they make in the game? It seems incomprehensible. Equally, a trial judge who has overruled the same objections several times is most unlikely to grant several, in fact, multiple peremptories because of the same subject that he said, no, it's not an error. And it's not worth the trial court's time to entertain such an objection, such a request for extra peremptories. It ain't going to happen. There is no point in a prudent trial counsel would not try the trial court's patience to that extent. Because
I noticed in your summary of argument, I was trying to go back and find it. And you referenced dismiss without further interrogation. Are you still contending that there should not have been any attempt to rehabilitate?
Yes, that's what Article 3516 says,
Okay.
unless I'm very much mistaken.
I understand. And opposing counsel says the bias has to relate to guilt or innocence. You arguing that occurred here? That
Yes.
the bias was aimed,
Most certainly.
and explain why in your view.
Well, the bias of the umpires towards the Yankees, nothing the commissioner of baseball, their boss, says will remove it. Is that not going to affect their decisions in the game? Somebody slides home, was he tagged out?
Who's going to win or lose?
Who's going to win or lose? Exactly. If the court has further questions, I'll be happy to answer. Thank you all very much.
Thank you, counsel. The case is submitted and you are excused to go. Thank you for your appearance today, and we will be in recess until this afternoon.
All rise.